So, after the Civil War, everybody who worked for a living had the right to a free labor market. And you can still find this in the law today. You have the right to a free labor market. This meant that all people could go out and find work, contract their labor for the highest wages they could get, and they would pay taxes as consumers when they spent their money. There were no sales taxes back then, by the way. The forces of slavery that had entrenched itself in the Democratic Party had been defeated in the Civil War. And whether or not the right to free labor continued would depend upon whether or not the politicians in power would respect the right. The former slaveholders were granted amnesty by President Johnson not long after Lincoln was murdered. This allowed them to get back into power in the state governments and get back into Congress too. These angry ex-slaveholding Democrats gave birth to the Ku Klux Klan and the Jim Crow laws. Needless to say, the slaveholders were very angry they had lost the war, and thus the power they had over the labor and wages of millions of ignorant human beings. You see, the newly freed slaves were ignorant because there were laws in the slave states that made it a crime to teach slaves to read. Well, why? Well, let's let J.H. Hammond of South Carolina explain this to you from Cotton is King. This comes from page 649. You seem well aware, however, that laws have been recently passed in all these states making it penal to teach slaves to read. Do you know what occasioned their passage and renders their stringent enforcement necessary? Well, I can tell you. It was the abolition agitation. If the slave is not allowed to read his Bible, the sin rests upon the abolitionists, for they stand prepared to furnish him with the key to it, which would make it not a book of hope and love and peace, but of despair, hatred, and blood, which would convert the reader not into a Christian, but a demon. To preserve him from such a horrid destiny, it is a sacred duty which we owe to our slaves, not less to ourselves, to interpose the most decisive means. If the Catholics deem it wrong to trust the Bible to the hands of ignorance, shall we be excommunicated because we will not give it, and with it the corrupt and fatal commentaries of the abolitionists to our slaves? Allow our slaves to read your writings, stimulating them to cut our throats? Can you believe us to be such unspeakable fools? Yeah. It hasn't been that long ago the phrase, the dumbing down of America, was fairly common. And now today we rank 28th in the world in education. Interesting. See, slavery in all its forms dumbs the people down, makes them ignorant, and looks with contempt and hatred upon all who dare speak out in opposition to it. The abolitionists were hated by the slaveholders. Their print shops were raided by pro-slavery mobs and destroyed. They murdered Elijah Lovejoy. As Senator Wilson stated back on March 28, 1864, while the Civil War raged on, "Sir, slavery, bold, proud, domineering, with hate in its heart, scorn in its eye, defiance in its mane, has pronounced against the existence of republican institutions in America, against the supremacy of the government and the unity and life of the nation, slavery, hating the cherished institutions that tend to secure the rights and enlarge the privileges of mankind, despising the toiling masses as mudsills and white slaves, defying the government, its constitution and its laws, has openly pronounced itself the moral and unappeasable enemy of the Republic. Slavery stands today the only clearly pronounced foe our country has on the globe. Therefore, every word spoken, every line written, every act performed that keeps the breath of life in slavery for a moment is against the existence of democratic institutions, against the dignity of the toiling millions, against the liberty, the peace, the honor, the renown, and the life of the nation. In the lights of today that flash upon us from Camp and battlefield, the loyal eye, heart, and brain of America sees and feels and realizes that the death of slavery is the life of the nation. The loyal voice of patriotism pronounces in clear accents that American slavery must die, that the American Republic may live. So, if some form of slavery should ever return and be enforced on the people, rest assured, the same hateful and arrogant spirit will accompany it. Now, the United States Supreme Court handed down rulings after the Civil War that were friendly towards liberty. One case summed out how precious the right to free labor was back then. In 1884, Justice Bradley said, "They established and declared one of the inalienable rights of freemen, which our ancestors brought with them to this country. The right to follow any of the common occupations of life is an inalienable right. It was formulated as such under the phrase pursuit of happiness in the Declaration of Independence, which commenced with the fundamental proposition that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. This right is a large ingredient in the civil liberty of the citizen. To deny it to all but a few favored individuals by investing the latter with a monopoly is to invade one of the fundamental privileges of the citizen, contrary not only to common right, but, as I think, to the express words of the Constitution. It is what no legislature has a right to do, and no contract to that end can be binding on subsequent legislatures." And in this same case, Justice Fields said, "As in our intercourse with our fellow men, certain principles of morality are assumed to exist, without which society would be impossible, so certain inherent rights lie at the foundation of all action, and upon a recognition of them alone can free institutions be maintained. These inherent rights have never been more happily expressed than in the Declaration of Independence, that new evangel of liberty to the people. We hold these truths to be self-evident, that is, so plain, that their truth is recognized upon their mere statement, that all men are endowed, not by edicts of emperors, or decrees of parliaments, or acts of Congress, but by their Creator, with certain inalienable rights, that is, rights which cannot be bartered away, or given away, or taken away, except in punishment of crime, and that among these are life, liberty, and the pursuit of happiness, and to secure these, not grant them, but secure them, governments are instituted among men, deriving their just powers from the consent of the governed. Among these inalienable rights, as proclaimed in that great document, is the right of men to pursue their happiness, by which is meant the right to pursue any lawful business or vocation in any manner not inconsistent with the equal rights of others, which may increase their prosperity or develop their faculties so as to give them their highest enjoyment. The common businesses and callings of life, the ordinary trades and pursuits, which are innocuous in themselves, have been followed in all communities from time immemorial, must therefore be free in this country to all alike upon the same conditions. The right to pursue them without let or hindrance except that which is applied to all persons of the same age, sex, and condition is a distinguishing privilege of citizens of the United States and an essential element of that freedom which they claim as their birthright. It has been well said that the property which every man has in his own labor, as it is the original foundation of all other property, so it is the most sacred and inviolable. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder his employing his strength and dexterity in what manner he thinks proper, without injury to his neighbor, is a plain violation of this most sacred property. It is a manifest encroachment upon the just liberty of the workman, of both the workman and of those who might be disposed to employ him, as it hinders the one from working at what he thinks proper, so it hinders the others from employing whom they think proper. So we can see here that labor is not only property, but it's the foundation of all other property. And the right to free labor is a sacred right. Well, this makes perfect sense, folks. If not for your ability to labor and earn money, could you have, for example, a car, a home, the tools of your trade, or any other property? Again, when this case was before the court, people were paid their wages in full and paid taxes as consumers. Another case that bears mentioning is the Boyd versus U.S. case. In this case, Justice Bradley said, "It may be that it is the obnoxious thing in its mildest and least repulsive form, but illegitimate and unconstitutional practices get their first footing in that way, namely by silent approaches and slight deviations from legal modes of procedure." Yeah, you sneak it in there. This can only be obviated by adhering to the rule that constitutional provisions for the security of persons and property should be liberally construed. A close and literal construction deprives them of half of their efficacy and leads to gradual depreciation of the right, as if it consisted more in sound than in substance. It is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. Their motto should be obsta principis. Obsta principis means resist the beginning. So let's move forward in history. We all know that today we don't receive our wages in full. Our wages are taxed. And if we refuse to comply with the power that taxes our wages can be garnished by both the IRS and most state governments. When did things change? In 1913, the 16th Amendment became part of the Constitution. This started the federal income tax. Now, in 1894, the Congress tried to impose an income tax, but the Supreme Court, in the case of Pollock versus Farmers Home and Trust Company, in 1895 struck down the income tax on the grounds it was a direct tax and therefore subject to the constitutional rule of apportionment among the states. It was the Democratic Party that wanted the income tax, and they finally got their way when the 16th Amendment became part of the Constitution. Now, what this amendment did was remove the rule of apportionment and allowed the Congress to treat the income tax as an indirect tax. See, even though it was a direct tax, the amendment said, okay, you can treat it as an indirect tax. This meant the revenue would go straight into the Treasury, and Congress could spend the money as they saw fit. The income tax did not tax wages when the income tax started in 1913. In fact, the exemption rate in 1913 was roughly 8 times the earnings of the average wage earner. Yeah, it was placed way above working people. The tax was placed far above the wages or labor of working people. It should be noted that an income tax was imposed during the Civil War to help fund the war. It was ended in 1872. This tax didn't tax wages either. Nowhere can you find where the legal definition of the word income included wages back in this period of history. The definition of income back then was limited to the gains and profits of business activity. For example, Senator James Simmons on the floor of the Senate on July 24th, 1861 said, "A man will say his house lost 5 or 10% by the wear of it, that the tenants have destroyed the woodwork and all those kinds of evasions. But nobody can mistake the word income. It is the net profits of a man for the year." Net profits of a man for a year? Does that sound like somebody's wages? That doesn't make any sense, does it? Just read the May 17th, 1913 Saturday Evening Post article entitled "The Income Tax" by Benton McMillan, a 10-term congressman, Democratic congressman from Tennessee. This entire article is on my website. the man who was editor of the Saturday Evening Post from 1899 through 1936 was George Horace Lorimer. Now, he knew what the income tax was all about. Now, let's read from Mr. Lorimer's March 31st, 1934 editorial. By income taxes we strive to redress the balance, and at the same time make the builders of great fortunes pay proper toll to the society which has made their success possible. So, Mr. Lorimer said the income tax was imposed upon the builders of great fortunes. Yeah, are you the builder of a great fortune? The Supreme Court, in the case of Eisner versus Macomber, which was decided in 1920, was clear about the fact that the word income, as used in common speech back then, was understood to be the gains and profits of business activity. Income was associated with the production of wealth. The main points from the very beginning of the case are of interest. Okay, here's one of the points. The Income Tax Amendment, Constitutional Amendment 16, must be construed in connection with the taxing clauses of the original Constitution and the effect attributed to them before the amendment was adopted. Yeah, the Supreme Court ruled, well, yeah, you can impose an income tax, but since it's a direct tax, it's subject to the rule of apportionment, and they didn't like that. Okay, now here's another point. Constitutional Amendment 16 did not extend the taxing power to new subjects, but merely removed the necessity which otherwise might exist for an apportionment among the states of taxes laid on income. Yeah, it didn't give the federal government any new taxing power, okay? Constitutional Amendment 16 should not be extended by loose construction so as to repeal or modify, except as applied to income, those provisions of the Constitution that require an apportionment according to population for direct taxes upon property, real and personal. Here's another point. The question of what constitutes income within Constitutional Amendment 16 cannot be concluded by any definition which Congress may adopt. Yeah, in other words, what the court's saying is, the legislature just can't redefine the law dictionary to accomplish whatever objectives they want to accomplish. Yeah, if you let the legislature define what income is, they can tax everything under the sun, can't they? Here's another point. Income, this is what tells you what income is. Income is the gain derived from capital, from labor, or from both combined. Something of exchangeable value proceeding from the property, severed from the capital, however invested or employed, and received or drawn by the recipient for his separate use, benefit, and disposal. Now, an example of a gain derived from capital and labor can easily be seen when a home builder builds a house and sells it. See, I've been in construction all my life, all right? The builder invests his money to buy the land, get the permits, pay for the materials to build a house. That's the capital. He also has to contract the labor of different trades to get the work done and thus has to pay for the labor. When the builder sells the house, the cost of the capital and labor investment is deducted from the sale price, and what's left is the gain, the profit. That is an example of income that the court in the Eisner case described. So when did things change? When did the definition of the word income get perverted to justify the government taxing our wages? Okay, I found this period in our history going through old volumes of weekly press. I knew there had to be a period in our history where things changed. The 1920s was a very prosperous time for the country. There were no sales taxes. The income tax affected less than 3% of the population. There were no payroll taxes. The free labor market that the 13th Amendment guaranteed to the people was respected, and the federal and by both the federal and state governments. Now, Herbert Hoover, who was the 31st President of the United States, pointed out how prosperous America was in the 1920s. He said, as to production, our system of stimulated individual effort, by its creation of enterprise, development of skill, and discoveries in science and invention, has resulted in production of the greatest quantity of commodities and services of the most infinite variety that were ever known in the history of man. Our production in 1924 through 28, for existence, in the flow of commodities, service, and leisure, resulted in the highest standard of living of any group of humanity in the history of the world. Now today, the people have to work about half of the year to support the government. In other words, all forms of taxation take about half of what you earn today. Now let's look back in the 1920s and see how much people had to pay to support the government. In his October 1932 speech on the consequences of the proposed New Deal, President Hoover said, "First, a proposal of our opponents which would break down the American system is the expansion of government expenditure by yielding to sectional and group raids on the public treasury. The extension of government expenditures beyond the minimum limit necessary to conduct the proper functions of the government enslaves men to work for the government." No income tax was imposed on people's wages when Herbert Hoover said that. If we combine the whole governmental expenditure, national, state, and municipal, we will find that before the World War, each citizen worked, theoretically, 25 days out of each year for the government. In 1924, he worked 46 days a year for the government. Today, he works for the support of all forms of government 61 days out of the year. And like I say, today we work about half the year. So, what is the period of our history where things changed? Like I said, it was the New Deal of the 1930s under President Franklin D. Roosevelt. Now, I could spend hours on this period in our history, but all you need to do is just go to my website and click on the old weekly press table of contents and read about it yourself. I've taken a lot of time doing this, so you can read about all the history of our country that's been hidden from you. Like I say, they've dumbed you down. They don't want you to know this. Franklin Roosevelt is held up to us in history as one of our greatest presidents. The truth is, he was a great deceiver. See, I had no opinion of Franklin Roosevelt or Herbert Hoover or anybody until I did all this research. But anyway, FDR, that's what they called him, Franklin Roosevelt back then, he did more violence to the Constitution than any other president in our history. Herbert Hoover, who was the last Republican president in the tradition of Abraham Lincoln, tried to warn the people back then not to allow the federal government to expand its powers without amending the Constitution. His warnings fell on deaf ears to a lot of people. The New Deal began with an emergency session of Congress called by President Roosevelt in the spring of 1933. This emergency session of Congress lasted 100 days, and this is all the time it took for the Congress to surrender its legislative powers to the executive branch. All of the legislation the Congress passed during this emergency session of Congress was written by a special intercabinet Roosevelt appointed, which was called a brain trust. They were the ones who wrote all the legislation. This was in violation of Article 1, Section 1 of the Constitution. Up to this period in our history, all legislation that became law in the United States had been written by your elected representatives in Congress and their staff. This made Congress a rubber stamp. Yeah, when the executive starts writing the legislation, they just stamp it. And that's the way the Congress has been ever since, for 80 years. The Congress rarely ever reads the legislation they pass into law that's written by the executive branch. Here's some important excerpts from an article by Garrett Garrett that appeared in the August 12th, 1933 issue of the Saturday Evening Post. Social revolutions are, by nature, sudden and more or less incredible in the time of taking place. The intended consequences are two, namely a transfer of power and a transfer of wealth. Formerly, the power to be transferred was political power. In the modern case, it's economic power. But the essential design is in no way altered. Power for its own sake, political or economic, is not the popular object. People themselves cannot exercise it. They are obliged to delegate it to a dictator. reserving only the right to change dictators, even if necessary, by another revolution. A redistribution of advantage and wealth, that is the popular object, and that is what the power is for. By this definition, the country is in a state of revolution. It was unpredictable. When Congress assembled on March 9th, under an emergency call, no one knew what it was going to do, nor did it know itself what it was going to do, either at the beginning or day by day thereafter. It went from one step to another with that kind of uncertain certainty peculiar to sleepwalking. It received the demands of the revolution serially in the form of pre-prepared laws and enacted them with practically no debate and no drama. In the early morning of June 16th, it adjourned. The entire life of the session had been 100 days. That was all the time it took to erect a complete temporary dictatorship in the person of the president, standing for the popular will. Yeah, let's read some more. Attacking the nightmare of fear. Yeah, you have nothing to fear but fear itself. That was a big thing Franklin Roosevelt said back then. His first official act, Roosevelt, was to suspend banking operations throughout the whole country for a period of days by decree, to everybody's instant relief of mind. People were not afraid to be entirely without money in a land of plenty. Their common sense saved them at that point, but the fear of losing their money before it was lost had caused them to behave as at the deluge. Then immediately, in this nightmare of fear, two intentions began to move. One was the simple direct intention, by any means, legal or extra-legal, to deal with the crisis as a national emergency. The other might be called the ideal intention of an academic mentality that surrounded the president, pleasantly named the Brain Trust. This was a complex intention, acting with the other on the emergency, but acting upon it in an oblique manner from a very high point of view. One who could get that point of view would see not restoration, not prosperity again as it was or ever had been before, liable to crisis and mocked by frustration, but in place of that, a complete new order, scientifically planned and managed, the individual profit motive tamed by government wisdom, human happiness, ascendant on a plotted curve. See what they said? They were starting a planned economy. See, we're going away from the free economic system. We're going to have a planned economy. And actually, what I did, Bob Dole, in his campaign speech, in one of his campaign speeches in 1996 when he was running against Bill Clinton, I caught this. He said this. He said, we must move away from a planned economy. Yeah, he knows. They know, people. They know. Okay, the Brain Trust at work. Such acquiescence in the heart of Congress reacted with a certain effect upon those who were writing the acts of the new order. Ideas more and more daring went into the conference tubs, and the crystals sent up the hill in haste, marked by or for the administration, were more and more astonishing. On the floor of the House, one member exclaimed, in some cases, bills have been passed before they were printed, before any copies were available, even for the leaders of the House or members of the committees sponsoring them, without anyone knowing what they contained. Yeah, they were voting into law stuff that they didn't even have copies to read them. These bills were passed under special rules, which made the House of Representatives merely a rubber stamp to furnish the necessary legality to the desires of the executive branch of government. And here's another little excerpt. To anyone who said such an act as this one or that one was unconstitutional and would be so held by the Supreme Court, an answer that became current was, those who imagine the new order can be defeated by an appeal to the Supreme Court on the Constitution will be disappointed. Do they think the government, having gone so far, would hesitate to give the Supreme Court a new mind? Such were the conditions under which this country embraced a dictatorship, with no conscience intention, no serious debate about it, by implied consent, all in 100 days. This is where the government you live under today had its roots, people. Now, the New Deal of the 1930s marks the beginning of the government we live under today. Sterling Edmonds, a lawyer and member of the St. Louis Bar back then, wrote a book that was published in 1940 called The Roosevelt Coup d'etat, 1933 through 1940. The link to this book is on my website, but Edmonds was right. What happened back then was a sudden coup d'etat, a sudden overthrow of the legitimate government. Just look at the title of chapter 1 of his book, Legislative Steps Towards Executive Control of the Social and Economic Life of the States. And here's what coup d'etat means: a sudden, decisive exercise of power whereby existing government is subverted without the consent of the people. Yep, that's what happened back then. Now, Edmonds exposed who comprised the inner cabinet that wrote all the laws which formed a massive executive bureaucracy. On page 7, he said, Roosevelt, head of the Democratic Party, was elected to the presidency of the United States in 1932 by a popular vote of 22,821,857 to Mr. Hoover's 15,761,841. And his party's candidates won 322 of the 435 seats in the lower house, with 68 of the 96 seats in the Senate. See, they had an overwhelming majority, so they could do whatever they wanted. He appointed no man of recognized ability or attachment to our free institutions to his cabinet posts. Among those he did appoint were 4 not of his party, who were associated with the elder La Follette in his progressive and socialist campaign for the presidency in 1924. Yeah, his brain trust was a collection of socialists. He also surrounded himself with a group of young radicals as a sort of inner cabinet, as his special personal advisors. It was they who secretly concerted and drafted the plan for the overthrow of constitutional government, which he put into execution. Now, the Supreme Court tried to hold their ground by declaring New Deal laws unconstitutional, which they were. One case was a 9-0 decision. All the justices agreed on this one. The case was ALA Schechter Poultry Corporation versus United States, was decided in 1935. And let's read what the court said. Oh, and by the way, God almighty, Roosevelt got mad about this, that a darn chicken farmer beat him in the Supreme Court in a 9-0 decision. But anyway, let's read this. The question of the delegation of legislative power. We recently had occasion to review the pertinent decisions and the general principles which govern the determination of this question. All legislative powers herein granted shall be vested in the Congress of the United States, which shall consist of a Senate and House of Representatives. That's the very beginning of the Constitution, Article 1, Section 1. And Congress is authorized to make all laws which shall be necessary and proper for carrying into execution its general powers. The Congress is not permitted to abdicate or to transfer to others the essential legislative functions which with it is thus vested. Yeah, Congress is not allowed just to take its legislative power and say, here, executive branch, you can have it, and we'll just rubber stamp what you do. That's the way all the laws have come into being for 80 years now, folks. Anyway, it's pretty basic stuff, but it enraged Franklin Roosevelt. He viciously condemned the court. He launched an attack against the court, and at one time, 50 or more bills were in Congress which attacked the independence of the courts. Roosevelt had a court-packing plan secretly devised by Attorney General Homer Cummings, and after Roosevelt was reelected in 1936 by a landslide, he unleashed the plan. This caused the Supreme Court to begin upholding New Deal laws to prevent itself from being perverted to a high degree, but it really didn't matter. As justices died and retired, Roosevelt was able to pack the court anyway. Rather than amend the Constitution to legalize this massive expansion of executive powers, Roosevelt chose to pack the courts with corrupt judges that created all the legal fictions needed to pronounce New Deal laws constitutional. Hence, de facto government was given a legal appearance, and de jure government came to an end. Since those of us living today have been born into this system, we are blinded to the fact that the government we live under is illegitimate, since de facto power controls the media, the press, the educational systems of the country. In other words, de facto government controls everything our mind is fed from the cradle to the grave. The first law that began taxing wages and began associating wages with income was the Social Security Act of 1935. Now let's examine this. Remember that the Supreme Court in the Eisner case in 1920 said that the 16th Amendment granted no new taxing powers to Congress? Now let's read from a March 7, 1936 Saturday Evening Post article on Social Security. Okay, Mr. Roosevelt was perfectly correct. The passage and signing of the Social Security Act was a historic event, for it undertakes to establish, as a continuing policy in this country, fundamentally new concepts, new in our system of government, at least, of the relations between the federal government and the states, and between the states and their citizens, and between all citizens and the federal government itself. The Act sets up, for example, such innovations as these: a federal income tax that goes all the way down to the bottom of the economic scale, taking toll from every man and woman, boy or girl, who works for wages no matter how low. Is that not new in our national scheme of things or not? Yeah, new. Remember what the court said in Eisner. The 16th Amendment did not grant any new taxing powers. So we can see here in this article, Social Security Act imposed a new taxing power that the federal government had never exercised before. Let's look further at how taxation on our wages had its start. This brings us down to the final item: a new kind of tax which reaches more citizens and cuts across lower levels of individual economic status than any direct tax ever levied in America. It is an income tax on all wage earners, levied directly on their pay envelopes. Yeah, there wasn't paychecks at the time. You got your money in cash in a pay envelope at the pay window for old age benefits. It is to be deducted by employers from all regular wage or salary payments every payday and turned over to the federal treasury. This tax runs at the same rates as the old age benefits tax levied on employers. Beginning on January 1st, 1937, the rate is 1%. It applies, however, only to wages or salaries below $3,000 a year. If you earn more than $250 a month, you don't have to pay this tax on the excess above that income. Every third year thereafter, the rate goes up by 0.5%, until in 1949, it's running at 3% of every worker's pay. Okay, folks, look at your paycheck. Do you get to keep 97% of your wages? Didn't work out the way they planned, did it? See, today we live under a government that looks at our wages as their property to do with as they please, with no restraints. Now, the first Social Security cards look like this. Yeah, Social Security Act, account number. Yeah, has been established for so-and-so. An account number. You see, the Social Security was sold to the people as an old age pension account that all workers contributed to. Now look at the card today. Now the card just shows you have a number, and that the number isn't associated with any kind of account. What does this mean? Just like Frederick Douglass's master in the 1830s had the power to take his wages from him, so today the federal and state governments exercise this power on a massive scale. The income tax was never intended to be used in this manner, and the politicians and the courts know this. They're not dumb. In fact, in the first case where a wage earner made it before the Supreme Court in the 1991 term that had been convicted of willful failure to file, the court said, where possible, court interprets congressional enactments so as to avoid raising serious constitutional questions. See, the court reversed Cheek's conviction on the statutory ground of willfulness, and thus didn't have to rule on the constitutionality of taxing wages. To this day, the Supreme Court hasn't ruled on the constitutionality of taxing wages. I wonder why. The truth is that your labor is the property of the Democratic and Republican parties, and your Social Security card is their title deed to your labor. Yep. Look at your Social Security card. It's the title deed to your labor. Your labor has become their slave property. This is the bitter truth, whether you like it or not. Anyway, you can study the New Deal like I have by going to my website and reading the articles from back then. Then you can fully understand how the government we live under today had its beginning. Now let's examine our Constitution and see what's left of it today.